So good morning, ladies and gentlemen. We are going to start our panel on what, at least to me, is a very exciting topic. Is international arbitration stagnating, and would Asian arbitration centers pour fresh blood in dispute resolution procedures? To address those questions, we have here a very distinguished panel, and we are very honored to have the Indian Minister for Justice, Law and Justice, present with us today, together with representatives from the Russian academia, main arbitration centers in Asia, and the main arbitration associations of Russia and Asia. My name is Renaud Sorieul. I am the Secretary of the United Nations Commission on International Trade Law, and it gives me great pleasure to moderate this panel. It also gives me an opportunity to perhaps remind everyone of what UNCITRAL does in the field of dispute resolution and what it is. First and foremost, this is a good opportunity to remind everyone that UNCITRAL is not an arbitral institution, despite the fact that we receive on a weekly basis requests for interventions in individual cases. We do not intervene in arbitrations except by way of preparing the legal framework that accompanies and hopefully supports arbitration, be it commercial or investment arbitration. By providing the legal framework, I mean a very broad variety of instruments, ranging from the New York Convention on recognition and enforcement of foreign arbitral awards, which is administered by UNCITRAL and which continues to form the main framework of at least commercial arbitration, arbitration model law, the arbitration rules. I am also very happy to this opportunity to dispel the misconception that the UNCITRAL rules or UNCITRAL law is for ad hoc arbitration. It is not only for ad hoc arbitration, it is also intended to support the activity of arbitral institutions and to be of use in the context of administered arbitration, as will be demonstrated by the many centers present here today who provide services also on the basis of the UNCITRAL arbitration rules and whose own rules are frequently developed on the basis of UNCITRAL models. With this, I would start immediately with the speakers. We have a fairly large group of speakers. We have 2 hours, so I would propose that each speaker, with or without a PowerPoint presentation, speak for 5 to 10 minutes. And once we have heard all the presentations, we should have some time for discussion. The merit of a session like this, or the principal attraction of a session like this, is the opportunity to make it very interactive, and I do hope we will have a lively discussion after the presentations. I would perhaps first of all start with our host country and with the perspective from the Russian Federation, and asked Mr. Vladimir Khvale, who is the chairman of the Russian Arbitration Association, to address us. Thank you.
Thank you very much, Mr. Chairman. I understand that it is challenging to talk on a Friday morning after a wonderful event all of us had yesterday evening, but I'll try to be slow in speaking from one side, but entertaining and useful from the other side. May I ask my presentation to be put on the screen? The topic of our discussion today is pretty controversial because we start with the proposition that international arbitration is stagnating. Indeed, we hear today a lot of voices who are saying that arbitration today, especially international arbitration today, is not what used to be 50 or 40 years ago, because it used to be a quick and efficient way of dispute resolution. Today, international arbitration is not quick and very often not efficient. It's especially from perspective of Russian lawyers, where we have state courts which could resolve disputes within, at the first level court, 3 months, and if you appeal, you'll get a final judgment of 2-level courts in 6 months. In such situation, when Russian lawyers are hearing that the average time of considering disputes by arbitration in many arbitration institutions would range between 1.5 years and 3 years, they are really surprised when they hear that this is a quick way of dispute resolution. By no means, of course, it's quick in comparison to Russian state courts. Also, if you look into numbers of some arbitration institutions, you might think that arbitration indeed is stagnating because the numbers are increasing, but not in a manner which one would expect. But I'll come to this issue later. Where I should point out how to switch. Can somebody assist me? It works. Okay. Let me start with arbitration in a former Soviet Union, because for a long time the only arbitration institutions in Soviet Union was a Foreign Trade Arbitration Commission at the Soviet Chamber of Commerce. However, after collapse of Soviet Union, new arbitration centers emerged. And in addition to Russia, and we know that in Russia there are many arbitration institutions, although majority are not reliable, but still there are many arbitration institutions. New arbitration centers were created in Ukraine in 1992, in Kazakhstan, in Belarus in 1994. And these arbitration centers took part of the pie of the disputes which before came to Russian Soviet Chamber of Commerce, now are considering at these arbitration institutions. In some republics of former Soviet Union, there's almost arbitration boom. I could give you as an example Latvia. It's a small country with population of a couple of million people, where they have almost 1,000 arbitration institutions. So one could say that there's one arbitration institution for 1,000 people, including those who are going to the school and are retired. Is it a good example of development of arbitration? I would say no, because vast majority of these institutions are not really reliable. So coming back to a number of arbitration institutions, as I said, in Russia, there's no reliable statistics, but some people are saying that there's almost 1,500 arbitration institutions. There are almost 500 arbitration institutions domestic in Ukraine, because some people are saying that currently Ukrainian law on international arbitration allows for only Ukrainian Chamber of Commerce to administer international disputes. I want to provide here some statistics with regard to number of cases submitted to the arbitration court at the Russian Chamber of Commerce, Ukrainian and Belarusian Chamber of Commerce. You will see here the yellow bars reflecting number of cases submitted to Ukrainian Chamber of Commerce. Of course, one might say that it is evidence of popularity of arbitration in Ukraine, but this striking number of cases is rather explained by very peculiar provisions of Ukrainian law on international trade, where Ukrainian companies are subject to very heavy sanctions in case they do not return their currency proceeds from abroad, unless they apply to arbitration institution with their dispute. So this has encouraged many Ukrainian companies to apply to arbitration at the Ukrainian Chamber of Commerce. But if you look into other statistics, this is statistics for last 10 years, you will see that number of cases, although they grew, but they did not grow significantly. Let me show you some other statistics. This is related to traditional arbitration institutions, ICC, LCIA, Stockholm Chamber of Commerce. You'll see here CATAC, which is Chinese Arbitration Commission, and AAA, American Arbitration Association. You'll see that number of international cases is growing at AAA. It's also growing with the other arbitration institutions, but as I said, if you look in a long-term perspective, this growth is not significant, much less than one would expect. But as I stated from the very beginning, it will be wrong to say that this evidence of stagnation of arbitration, because in order to understand how popular is arbitration, you should not take statistics of one particular institution in isolation, because you should also take into account the growing arbitration institutions, because number of their cases is increasing and they're taking part of their pie. Next slide has some statistics with regard to emerging arbitration centers. Emerging may be not correct with regard to Hong Kong arbitration centers, but at least it is new arbitration centers for Russian companies. What you could see from this chart, that there is, for example, a growing number of cases from Dubai International Arbitration Center, which is a very good example, because Dubai International Arbitration Center was created not long time ago, but it already has a significant number of cases, and many of those cases are related to Russian disputes, because Russian companies are very active in Dubai. Finally, I would like to touch a very sensitive issue, the issue related to anti-Russian sanctions and ability of traditional arbitration institutions to administer disputes with Russian companies which are included in a sanctions list. There are several issues related to it, because from one side we could say that arbitration institutions are to administer justice in a broad sense, because they are administering international disputes. From the other side, we know that arbitration institutions are private entities, although non-profit entities, but they are private entities and they are subject to their local regulations. Therefore, arbitration institutions registered in European Union are subject of regulation by European Union, including those related to sanctions against Russian companies. And we know from our experience and talking to some Russian companies that some arbitrations were significantly delayed or even stuck when one of the parties to arbitration was a Russian company under the sanction. There were cases when some of the arbitrators withdrew, some of the foreign arbitrators withdrew from cases involving Russian companies under sanctions, because these arbitrators were subject to US regulations which prohibit any dealing with the companies on the sanction list. And interpretation employed by various institutions is that serving as arbitrator is also to provide service to companies in the sanction list. This is why, as we know, some of the Russian companies, especially state-owned companies, are looking more in the East, because so far arbitration centers in Asia did not join, or Asian countries didn't join the sanctions, so it's less risky to submit disputes to these institutions. And we will hear later today what kind of service they could offer to Russian companies. The slide you see on the screen is the result of the voting we had at the conference in April related to sanctions and ability of traditional arbitration institutions to administer disputes. And participants of the conference were asked the question, to which extent the sanction wave against Russia affected the functioning of long-established European arbitration institutions. You will see that some of the respondents said that yes, it did have impact on arbitration institutions, but number of those who suggested this view was not very high. From the other side, what is really worrying is that many participants of the survey stated that they seriously doubt inability of European arbitrators to neutrally consider disputes involving Russian companies under sanctions. And finally, we ask one more question to participants: to which extent you will continue to use traditional arbitration institutions? I think the majority said that we will still continue using traditional arbitration institutions, although significant number, I think almost 30% will consider more Asian arbitration centers to be on a safe side. With this swift introduction, I will pass the floor to the other speakers to talk about other institutions, including traditional Russian arbitration institution. Thank you very much.
Thank you. I would now ask Professor Kostin to take the floor.
Дамы и господа, коллеги, доброе утро.
Ladies and gentlemen, colleagues, good morning.
I think that for practical reasons, I, as Mr. Hvaley, would follow up in English, so that the majority here are very well versed in the English language. And since I will have many opportunities to talk to our Russian people, as we are doing from time to time, speaking about arbitration. The topic about stagnation of arbitration is not very simple. Representing two traditional and eldest arbitration institutions in our country, and this is now I combine two seats. I'm head of the International Commercial Arbitration Court at the Russian Chamber of Commerce, which was established in 1932 under different name in the Soviet times, and head of the Maritime Arbitration Commission, which was established a couple of years earlier in 1930. So this prompts me one idea, that I was seated here to the very right, extreme rights, and right position, I mean very traditional. So we have kind of experience, and for many decades we were the only two institutions in the USSR and then New Russia. And as Mr. Hvaley rightly said, then in the beginning of 90s, there appeared many new institutions which created the situation which brought many people and the state to think about reforming the arbitration laws and arbitration practice. And I just, since the time is very limited, I just need to say that beginning May, our government introduced to our first chamber in the parliament the new draft law on arbitration, which is of a general nature, and the basic idea and the basic portion of this draft law, which is mainly relied on the model UNCITRAL law, but the basic and to some extent very new question for Russian arbitration is the role of an arbitration institution. The previous law, and still present, was very liberal about creating the institution. Well, just to put it very simply, under each legal entity, either private or public, you could establish an institution, no license, no registration, no nothing, and as Mr. Hole also rightly said, that there was some misuse of arbitration mechanism for not very decent purposes. So the specific chapter of this draft law is regulating how to create an institution, and the reform lasted for more than 2 years. And I might explain this, well, very lengthy time, that, those persons and institutions involved in drafting and the state organs were of different orientations. There were very traditional old institutions with a solid background, neophytes, etc., and there were different ideas how to approach the arbitration. In the beginning, I personally and my colleagues from the institutions, we were very afraid that the legalistic idea that we would create and invent the best law in the universe, or perhaps even wider than the universe. And this idealistic approach, is not consistent with real arbitration. So I just must say that we have a dualist system. We have the law for domestic arbitration. Now we have the draft for domestic arbitration, including the portion for the institution, which would also relate to international arbitration, and the law on international commercial arbitration, which was introduced in 1993, and which is practically the same text as the model law edition 1985. And this was introduced in our parliament intentionally. And the very simple idea is that international arbitration needs a very good degree of unification. So speaking not only to persons who are legal persons, who are advocates or arbitrators or academics, but for speaking and talking with entrepreneurs and being asked, what is the regulation? I said, well, no problem. You just read the model law in any language, official language of the United Nations. This is our law. And some slight deviations could be explained in 1 or 2 minutes. And in the beginning of the reform, we were afraid that the deviation from the model law would be very far-reaching, and the proposal was to have the one law. So the idea was Great Britain, England, one law. Sweden, one law. United States, Federal Act. So we also need to have one law, and we will have the best arbitration in the world. No, this is very naive. This is a very neophyte approach. So finally, within these 2 years, or more than 2 years of reforming, we were lucky to sustain the model law as is, with a very important exception. Still, we don't have in the draft law for international commercial arbitration, which is awaiting its introducing into the parliament, one very important portion concerning security measures, which is very hot topic in international arbitration, and additions to the model law for 2006 devoted much attention to this question. And the chamber and the people, conservative arbitrators, 3 years ago introduced the draft law proposing, updating the current law on international commercial arbitration. It also surpassed the first reading in the Duma, in the Parliament. But then when this overall reform started, well, this draft law is for some time is forgotten. But we hope that during the parliamentary debates on the law, we would be successful here. The draft law, as I said, introduced, says that now to create the institution, there would be a necessity to create non-profit legal entity, which would require the permission to act as an arbitration institution from the government. Well, there are debates which particular organ in the government would be responsible, but this is not the very important issue. The result, I wouldn't say personally that it's the best result, but the only compromise. So those who complained about some deviations from the normal arbitration practice said that, well, if a state needs to control, there should be some kind of permission. Anyway, I feel that I don't have more than 1 or 2 minutes, and just to conclude and to give some sense of real arbitration practice. In the institutions which I represent, we try to sustain those initial ideas behind the arbitration. Simplicity, reasonable, combination between the time is money, quality and arbitration fee. And if we, the community, who is interested in using the eldest juridical mechanism for solving disputes, which will never stagnate until the mankind would be on this planet, the idea is that we need, in my opinion, to combine efforts to try to sustain these initial values for arbitration. So efficient, speedy, understandable way of solving international disputes. And what is very clear that in Russia and in the former Soviet Union, the international commercial arbitration always was viewed as the best way of solving international disputes. And many say that this is alternative way of resolving disputes. In practice, there is no alternative for international arbitration in the international commerce. I'm very thankful for your attention. Thank you.
Thank you very much, Professor Kostin. It's certainly good to hear that what will certainly be the best arbitration law in the world is still based on the UNCITRAL model law. And it was particularly interesting to hear that we still have, of course, with the rich arbitration tradition and practice in this country, a bit of the terminological issue of deciding exactly what is arbitration understood in the more common way as opposed to arbitration as understood, as it may have been understood in this country for many years. Thank you for that. Of course, what was said about the notion of arbitration institution having to be registered with government authorities raises particular questions, which I'm sure we will have opportunities to discuss later today. Now turning to the Asian approach to arbitration, I think we are very fortunate, as I said earlier, to have the presence today of His Excellency the Minister for Law and Justice from the Republic of India. You have the floor, sir.
Chairperson of the session, dignitaries on the dais, delegates, ladies and gentlemen. It is my privilege to represent my country and participate in the international conference at St. Petersburg, organized by the St. Petersburg International Legal Forum. Such conferences are a platform for sharing each other's experience and good practices and to discuss changes needed in the law in the ever-changing needs of the world community. In the liberal economic era, boundaries of nations have become redundant in business world. Allowing free trade and commerce in the global world is the motto, and today's good governance. With the increase of trade and commerce, number of commercial disputes bound to arise. Having speedy, cost-effective, and fair settlement of commercial disputes, preferably in informal way, is the key for becoming leader amongst the developing countries. Arbitration is a common private dispute resolution mechanism. Generally, parties choose arbitration over litigation because arbitration is usually faster, more efficient, and less expensive than litigating a dispute in court. Sometimes it is referred as ADR, which means alternative dispute resolution. Arbitrators are paid to decide the parties' dispute. Arbitrators are usually trained to handle disputes. They can be lawyers, former judges, and even those who have no legal training, such as accountants, architects, and engineers. Resolution of dispute through arbitration is not unknown to India, and it was prevalent in ancient times also. With the growth of international trade and commerce, there was an increase in dispute arising out of such transactions being adjudicated through arbitration. One of the problems faced in such arbitration was related to recognition of enforcement of arbitral award made in one country by the courts of other countries. It was sought to be removed through various international conventions. India has become a signatory to both 1923 Protocol and 1927 Convention on 23/10/1937. In order to give effect to both the 1923 Protocol and 1927 Convention, the Arbitration Protocol and Convention Act 1937 was enacted. Thereafter, United Nations adopted the Convention on Recognition and Enforcement of Foreign Arbitral Awards at New York in 1958. India became a state signatory to this convention on 13/7/1960. The Foreign Awards Recognition and Enforcement Act 1961 was enacted to give effect to New York Convention. With the increase of international transactions and agreement, model law was adopted by United Nations Commission on International Trade Law in 1985. The model law was designed to assist states in reforming and modernizing their laws on arbitral procedure so as to take into account the particular features and needs of international commercial arbitration. Taking into account the said model law, Parliament enacted the Arbitration and Conciliation Act 1996. The main purpose of the enactment of the said act is to encourage alternative dispute resolution methods for speedy dispute resolution without much interference of the courts. In fact, Section 5 of the Act provides that, notwithstanding anything contained in any other law for the time being in force, in matters covered by this part, no judicial authority shall intervene except where so provided in this part. The 1996 Act not only contain provisions relating to domestic arbitration, but also contain provisions relating to execution of foreign awards under the Geneva Convention and New York Convention. Timely disposal of commercial disputes is the need of the hour. The commercial disputes, especially of high value, involve complex facts and question of law. Therefore, it is felt that there is a need to provide an independent mechanism for their early resolution, which will also give a positive image to the investor world about the robust Indian legal system. A bill for establishing separate courts for adjudication of high-value commercial disputes has been introduced in the Parliament. Our government has under its consideration proposal for making arbitration as preferred mode for settlement of commercial disputes by making it more user-friendly, cost-effective, and expeditious disposal of cases. The government is committed to improve its legal framework relating to arbitration. The Law Commission of India, in its recent report, has recommended various amendments in the Arbitration and Conciliation Act 1996 so that India may become a hub of international commercial arbitration. Taking into consideration the Law Commission's recommendations and suggestions received from stakeholders, the Government of India has decided to amend the Arbitration and Conciliation Act 1996. The proposed amendment will provide a legal framework for time-bound disposal of arbitration proceedings in a cost-effective manner and will also accelerate enforcement of foreign awards in India. Arbitration is one of the services being paid handsomely and at the global level. An arbitral institution with conscious office bearers can ensure that the proceedings are conducted in the interest of the parties. International arbitration institutions provide model clauses so that parties, while incorporating them in their contracts, can aid smooth progress of arbitration. They also provide for a definition-free schedule. They determine whether there is a frame basic agreement to arbitrate, decide on the number of arbitrators, appoint arbitrators, decide challenges against arbitrators, ensure that arbitrators are conducting the arbitration in accordance with their rules and replace them if necessary, determine the place of arbitration, fix and extend time limits, determine the fees and expenses of arbitrators, and also scrutinize the arbitral awards. The way world community is choosing Singapore, Hong Kong, India, and other Asian countries as a preferred place for arbitration indicate that world community find it more convenient, cost-effective, and user-friendly environment for arbitration proceedings in the part of the world. Indian judicial system is increasing turning to arbitration and seen a considerable rise in institutional arbitration. According to the study carried out recently, in the last 3 years, India has seen a growth of nearly 200% in the number of disputes that have been referred to arbitration. The entry of professional institute in the market has brought in efficient structure, competence, world-class facilities, credibility, quality service, and effective case management. This has resulted in growing popularity of institutional arbitration in India. Once again, I convey my thanks to the organizers, and I also thank them for their excellent arrangements made for the effective participation of the delegates. Thank you. Jai Hind.
Thank you very much, Minister. As was to be expected, we heard words of wisdom coming from India, and indeed, if arbitration is to preserve its traditional advantages of cost effectiveness, speed, efficiency, adaptation to the needs of businesses, a lot of efforts will have to be put in not only updating legislation, but also ensuring that legislative and the judicial practice follows in a manner that effectively supports arbitration. And now coming to the speakers representing the arbitration centers of Asia. We are fortunate to have here three of the most active, successful, and vibrant centers in the region. I'm pleased to give the floor to Mr. Kevin Nash, who is the Deputy Registrar of the Singapore International Arbitration Center. You have the floor.
Thank you. It's very exciting to be in St. Petersburg. I suppose the question of whether or not arbitration is stagnating and whether the Asian institutions can inject new life, it seems like arbitration may be shifting because arbitration in Singapore is alive and well. There's been a period of growth that is almost unprecedented over the last 5 years and the last 10 years. So there is new life. There's a shift towards Southeast Asia, and not just for contracts with Russian parties in Southeast Asian countries. There's really countries from all over the world are now coming to Singapore. When you're looking at the reason for arbitration in Singapore, so certainly the presence of SIC, which is now one of the busiest institutions in the world, has had a big effect. But in order to make parties come for any kind of arbitration, for ad hoc arbitration, you have to have all the necessary fundamentals in place. Singapore, at least by some metrics, is thought to be the third most popular seat of arbitration in the world, which is really quite astounding when you think about it and you think about the more traditional centers. Singapore is also the fifth most popular seat for ICC arbitrations. A lot of investment disputes being heard in Singapore. So really the overall activity in Singapore is growing and getting increasingly strong. You look at the reasons for this. Of course, you need to have modern, best-in-class legislation, which Singapore has with its International Arbitration Act, which incorporates the UNCITRAL model law. You need to have a judiciary that will support the arbitral process. Singapore's judiciary, internationally renowned, fiercely independent. You need to have incentives in place so that parties in Singapore complete freedom of choice of counsel and law firms. So if Russian parties are coming to arbitrate in Singapore, they can bring their lawyers. You can instruct lawyers in Singapore. So you need to have that flexibility and freedom. And another big factor too has been Maxwell Chambers. Maxwell Chambers was the world's first fully integrated dispute resolution complex, which has now been emulated around the world. The KLRCA now has an absolutely stunning complex in Kuala Lumpur. And what this is you have all the major institutions are represented in this building. They're tenants in the building, just like SIC. And the top 2 floors are hearing rooms. So an absolutely beautiful facility. Very fun to be in the elevator every day because you're never sure who you might see because there's always hearings happening and it's a very active place. In terms of SIC and this growth that I've been talking about, so SIC had 222 cases last year, 259 cases in 2013, countries from 58 jurisdictions, 6 continents, still waiting for a case from Antarctica, but we've got cases from all the other jurisdictions. And again, when you're looking at an institution moving to an international sort of presence, it's having countries from countries where Singapore is not involved. So United States, China, choosing to have their arbitration at Singapore. When you look at the Secretariat, I'm the Deputy Registrar of SIC, so I assist the Registrar. We also have a team of 8 counsel who does the day-to-day management of the cases. And in selecting our counsel, again, we're looking at this sort of international focus of Singapore. So we have counsel from both civil law jurisdictions, common law jurisdictions, qualified in countries around the world. When you're looking at the institutions, of course, Singapore is familiar to some, but really, when you're looking at the institutional rules, these are familiar. Arbitration in Singapore will feel familiar to the traditional dispute resolution choices that may have previously been made, and we like to think that we're going to make it faster and even more efficient. One of the first things to look at, of course, is the costs. SIC calculates the costs based on the sum in dispute, so it's an ad valorem basis. That provides a certain level of cost certainty at the outset, so you know the maximum administrative fees, maximum tribunal fees. Depending on the circumstances of the case, if parties don't want to run through the schedule, you can also agree to the hourly rate. So that's the first thing that we look at, is having this cost certainty at the outset. Panel of arbitrators, we have arbitrators from 40 jurisdictions, over 400 on the panel. So this is a public, open panel. Parties can nominate from the panel or from outside the panel. And again, the quality of an institution is looking at the panel of arbitrators, and our public open panel, of course, has all of the most eminent names in the world. In terms of the identity of the institution, of SIC, of what we've done to become, in a short amount of time, a sort of international institution, one thing that's been a big factor is our special procedures. We have an expedited procedure where an award is made 6 months from the constitution of the tribunal. We've had nearly 200 applications for this expedited procedure since it was introduced in 2010. And it's proven to be really popular because, of course, that is the advantage of arbitration that parties are seeking this faster form of dispute resolution. And this expedited procedure, being able to have an award in 6 months, is a great advantage. SIC was also the first Asian institution to introduce the emergency arbitrator procedure. So if a party requires urgent interim relief prior to the constitution of the tribunal, an emergency arbitrator can be appointed. SIC has had 43 of these appointments since the provision was introduced in 2010, which ranks among the top in the world. We also do the scrutiny of awards, which is a big part of what we do. Particularly in Southeast Asia, there's a lot of different jurisdictions, and the enforceability of the awards, of course, is crucially important. To be able to have the Secretariat look at an award, look at the form requirements for the different jurisdictions, so whether an award might be enforced in Indonesia, China, Vietnam, and to be able to look at the form and just to make sure that everything has been taken care of, having that second pair of eyes on an award before it's issued and then released to the parties. We also now have the SIC Court of Arbitration, which is in charge of the overall sort of legal procedures. So now the president of the SIC Court of Arbitration is Gary Bourne, of course, one of the most eminent arbitration counsel and arbitrators in the world. This Court of Arbitration really takes care of all of the most important procedural steps in the arbitration, is what you want. You want your arbitration and the very important decisions being decided by the best in the world. And that's what SIC has with its Court of Arbitration, with these 17 eminent arbitrators and arbitration counsel from all around the world deciding those important procedural questions. You can see the kind of growth that Singapore has had over the last 10 years. And of course, we as institutions, we're always trotting out these numbers, but really, why are the numbers important? The numbers are important because you want an institution to have experience with as many types of disputes as possible. So when you're looking at the numbers, you want to establish a common metric. You want to look for cases, international cases that are administered by the institution. That's likely the number that matters. And you want to have those numbers and know those numbers because you want the institution to have seen almost every type of dispute. So SIC has an active caseload of around 500 cases administered under its rules. So we've seen, we think, almost all types of disputes, and for those new nuanced types of disputes, of course, we have the Court of Arbitration to then consult and assist us. In terms of the internationalization of Singapore, here are our top 10 nationalities. So all of the countries that you might imagine: China, India, Indonesia, but now we're seeing more and more cases from the United States and Europe as well. We also have had cases emanating from the CIS. What we're really seeing recently is a lot of inquiries from Russian parties who are evaluating their dispute resolution choices, which makes this a really exciting time for Singapore, for SIIC, is parties can look at their choices and now look at some new options, and hopefully Singapore is an option that makes sense for Russian parties. Again, in terms of the familiarity that you'll see at SIIC, governing law of contract, obviously parties can have any governing law of the contract, so Singapore law, UK law, laws of New York, all laws that we see often and of course would be seen by any institution. Same thing with the types of disputes that we're seeing, a lot of corporate commercial, international trade, construction, an increasing amount of shipping and maritime disputes as well. And finally, I'd just like to briefly touch on Singapore's suite of dispute resolution services. What Singapore has endeavored to do is really to become a one-stop shop for all international dispute resolution needs. Particularly relevant for arbitration is the Singapore International Mediation Center, which was launched in November of last year. SIC and SIMC have a unique ARB-MED-ARB protocol, of course, where an arbitration is commenced, then stayed and sent to mediation. This allows the parties an opportunity to come to a mediated settlement and then have a tribunal that can give effect to that settlement by way of a consent award. And if the parties are not able to reach a mediated agreement, then you have a ready and standing tribunal ready to proceed with the arbitration. So subject to the circumstances of dispute, something that might make sense for parties. And of course, you now have the Singapore International Commercial Court for international litigation. So in Singapore, arbitration, of course, which we focus on, but also international mediation and international litigation. So the scene in Singapore right now, very exciting, and we're hoping to see, of course, a lot more Russian users in the years to come. Thank you.
Thank you. We are gradually running out of time. I would now quickly give the floor to Ms. Ruth Stackpool-Moore, who's the managing counsel and the driving force behind the Hong Kong International Arbitration Center. You have the floor.
Good morning, everybody. Thank you very much for joining our session, despite what I think everybody enjoyed a fabulous evening last night. I will try and be brief because there are a lot of speakers, but I would also like to just give you an introduction to Hong Kong. It's probably, as we have all the centres here, one of the most well-known arbitration centres, not only in Asia, but also in the world. And so I'd like to introduce it to you this morning. If I could have my slides up, that would be fantastic. Thank you. Could you go back to the beginning, please? Here we go. So the structure of my presentation this morning, I did mention I will try and be brief. I'll speak for probably 2 or 3 minutes, and then actually I've seen a few eyes closing. So to engage you a little bit more, I actually have a video that might be a more fun way to introduce some of the best aspects of arbitration in Hong Kong. But like Kevin, I think from our perspective in Hong Kong, arbitration is definitely not stagnating. I think from that perspective, Asia has a lot to add, both for Russian parties but for arbitration in general, in terms of the innovations that are coming out of the jurisdictions in Asia and what they add to the practice from other jurisdictions around the world. So I think really the background to why Hong Kong has been for some time the centre of arbitration in Asia, it's important to think about why it's where international parties choose to do business. Because when you look at doing business, there's always disputes that follow. So really, Hong Kong now for some time has been leading Asia and also the world in their recovery from the global economic crisis. It provides very excellent access, both commercially and geographically, to the rest of Asia. It's also very well connected to mainland China, obviously, but also the rest of the world. For over 20 years, it's been voted as having the highest level of economic freedom, which is very important for those who are looking to do business and also think about disputes in the region. It's one of the leading financial centres in the world. It has a service-oriented and low-tax economy, which is also very important. And I think very importantly from this perspective is that it has a sophisticated common law legal system that's basically founded on the UK common law heritage. But this is within a jurisdiction that is less politicised than some other jurisdictions. In terms of Russian companies, very importantly, at the beginning of this year, a new understanding was entered into that allows Russian companies to list on the Hong Kong Stock Exchange. And this has led many Russian companies now to base their Asian operations in Hong Kong. So this includes VEB, Novatech, Gazprom Bank, who are all very active in Hong Kong. And I think most importantly from Russian parties and their particular interest now in turning to Asia is the fact that there are no sanctions imposed by Hong Kong. So then, now that we have the business background, and where there is business, there necessarily leads to disputes, we get to Hong Kong as being the home of arbitration in Asia. What you see on the slide is actually the entranceway to the HKIAC, which is very well located within the centre of the Hong Kong Central Business District. Like Singapore, like Kevin has explained, there is a fantastic framework for arbitration in Hong Kong. It has an excellent legislative framework. Its law is based on the 2006 version of the UNCITRAL model law. The courts in Hong Kong are very supportive of arbitration. There are a huge number of experts and professionals who deal in arbitration and all the supportive services that go with it, most of whom are multilingual and come from various international backgrounds, all practicing in Hong Kong. And also, very importantly, Hong Kong is part of the New York Convention, which is very important for the enforcement of your awards. I think also it's very important to note when you think about Hong Kong that it is also a neutral jurisdiction. Having returned now to being part of China, some people do have concerns that perhaps there is an influence of the mainland Chinese government on arbitration and also generally in Hong Kong. I can assure you that that's not the case. You may or may not be familiar with the principle of one country, two systems. This is in fact what does operate. So while there is a separate government in Hong Kong and there are separate legal systems, mainland China is a civil law system. As I mentioned earlier, Hong Kong is a common law system, and there really is no crossover between the two. I think very usefully you can see the World Economic Forum listing of judicial independence, which I've put on the slide for you. Hong Kong has been and continues to be ranked number one for judicial independence in Asia, which I think is very important. And as I mentioned, the courts are very supportive of arbitration, and as I said, they are very neutral. So then a bit more of an introduction to the HKIAC as an institution itself. The HKIAC is actually the oldest and most experienced international arbitration institution in Asia. It's actually our 30th anniversary this year. So we were established in 1985 and we've been handling arbitration cases ever since. As you can see, you may be familiar with the Global Arbitration Review. They recognise that basically regional arbitration started with the HKIAC when it was founded, and that there are now more than 40 institutions around Asia who are trying to emulate the success that we have enjoyed. As well as the length of our experience, we have also a significant annual caseload to demonstrate that we have also a high volume of experience as well. So last year we had 252 new arbitration cases filed with us, and of those 93% were international. The countries that were represented, we had parties from over 30 different jurisdictions, including from Russia. We have had a handful of cases every year over the last 4 or 5 years with parties who have come from Russia. And as with Singapore, we do expect this to increase over the next few years. An arbitration at the HKIAC will be conducted very much along the lines of an arbitration that you would be familiar with, and you will enjoy all the benefits of arbitration that you would expect from other centres as well, including the flexibility of the process, neutrality. Confidentiality is also very important and is highly protected in Hong Kong, and also enforceability. The extras that you would have associated with an arbitration in Hong Kong really stem from particular advantages within our rules, which I'll discuss briefly in a minute. We do provide very cost-effective services, particularly when you compare to some of the institutions in Europe and North America. And again, our administration is not affected in any way by the sanctions. So briefly turning to some of the particular advantages of the system that we have at HKIC, I mentioned our set of rules. These were introduced in 2013, and they have been widely recognised as containing features that are innovative and also that are leading the field. Particularly, this would apply to the choice of how arbitrators get paid, the ability to choose between paying the arbitrators of a percentage of the amount in dispute versus an hourly rate can lead to very significant cost savings in your proceedings, and the ability to choose between those is a unique feature of the HKIC rules. We do also have provisions which are world-leading, I think, in how we can deal with complex disputes. And by complex disputes, I mean those that involve multiple parties or multiple contracts. And that accounted for about 30% of our caseload last year. So it is very important to have the right provisions to deal with those circumstances. We do also provide emergency arbitration, so you can get very quick interim relief, either in the emergency context or throughout the usual course of your arbitration. And we do also offer an expedited procedure, which will let you have your dispute resolved within 6 months. They're the main features of the rules. The other main features I think that are very important of an arbitration at HKIC is that we do make reliable appointments if we need to. We have a panel of arbitrators with over 450 experts from around the world, but you are not limited to choosing your arbitrator from that panel. I mentioned that Hong Kong is part of the New York Convention, so your awards will be enforceable. We do have an excellent track record of enforcement, and particularly in mainland China, where it can be somewhat problematic. I've mentioned the cost advantages already, and I think the final advantage is that we have a very excellent and 5-star hearing facility. Here, and I think the picture has come up well on the screen for you, is one of our hearing rooms in use for a case. Our facilities were fully renovated 2 years ago. Although it's a black and white picture, they are very light, bright, and they contain all the modern amenities that you would wish to have in your arbitration. So for all of those reasons, I think that Hong Kong should be the place for your arbitration, and I would like to leave you with a short video that should be quite fun for this time of the morning that just highlights
I'm
what
afraid
I've
there
said.
will be no time for a video at this stage.
It's only 2 minutes.
You've already spoken for 10 minutes. I'm sure everyone will be happy to watch the video on the website. Thank you. I will now give the floor to Datuk Sundra Raju from the Kuala Lumpur Regional Centre for Arbitration.
Thank you, Mr. Chairman. I'm going to actually quickly go through why you should choose Asia, simply because I think I need to set the stage and the effect of sanctions and how we come into play. Then we can talk about the centre. In fact, all the centres in Asia, KL, Hong Kong, Singapore, same points. Actually, we have premises, we have the updated rules, we have the people, we have the infrastructure. We are all competing for the same thing. So basically, is that I think we better look at the overall picture. Then you have to decide how you want to do it. I think first thing is that I was in Tehran last year, and the issue of sanctions came straight to my mind simply because the Iranian delegate complained publicly in the plenary session that ICC is not honoring its duty as the arbitral administrative body for ICC arbitrations, where Iran is concerned because of sanctions. Because the problem basically is that it could not actually deal with the money where Iran was concerned, and therefore it left the matter like that. So I think that was a problem. So that got me going, you know. And then first thing is that I think when you have sanctions, basically is that immediately, if I'm a Russian party, I will insist Russian law to be the way the sanctions should govern. And then there is a problem where arbitrators of the countries that impose sanctions, how are they going to deal with it? They have to follow their domestic arrangements. Then there is enforceability issues coming out from sanctions. And then there is also travel and trade embargoes that come about, and that can make hearings difficult, and then difficulty of collecting payments. As I said, the banks don't want to deal with monies and deposits and all these things. It's impossible to do that. But really, sanctions do not excuse parties from the performance of their contract. I think that's the point I want to make, that parties cannot claim monetary compensation just because they have to suspend or they want to suspend the performance of their contract. They can't. In fact, we had a conference recently, about a month ago in KL, and we talked about the issue of sanctions, how it affects contract. And in fact, people were trying to use things like force majeure, trying to overcome it. So what is the traditional criteria of selecting a seat? Neutrality, you need sophisticated legal structures, trained personnel, you have an independent judiciary, and then availability of expert panels, and then cost effectiveness and efficiency and expediency. Now, Western countries have always been popular. I think ICC and LCIA have been dominating. That's a fact. That's a fact. But I think now economic and political factors are becoming important. And when we deal with it, I think in the old days, because the West had a lot of economic activity and political clout, it was able to call the shot. I think now it's shifting. And when it's shifting, it actually is shifting because there is the issue of legitimacy of sanctions, impartiality and independence of the panel. There's always this suspicion. If a Western panel, where a country is involved in sanctions, imposing sanctions, would that panel be independent if you're coming from there? And then there is actually practical administrative problems and enforcement of awards. Now, then that's where we go to Asia. We have to go to Asia simply because a lot of Western countries are involved in Asia. They are moving to Asia. There's a lot of future business deals being made in Asia. There is a lot of existing disputes that require an alternative venue. And I think today you can hear from Hong Kong, from Singapore, and including myself, we talk about how we have transformed the arbitral landscape in Asia to deal with the modern way of doing business. So I think the first thing is that Asia has no political stake in sanctions against countries that include Russia, Ukraine, or Iran. I think that we have to be very clear. In fact, I think we are very reluctant. We are the people who followed the Peace of Westphalia. National sovereignty, we are not interested in interfering with the internal difficulties that people have. So then I think the issues really about impartiality and objectivity does not arise if you go to Asia. And then I think Malaysia particularly, we have been perceived to be neutral, always neutral, and we are apolitical. In fact, we have actually always traded with nations that were under sanctions. For example, Iran, 1980s, 1990s, even now, we are the main suppliers of palm oil to Iran until now. I think that shows the consistency of Malaysia's political stance. My political leadership basically says that, look, we just do business. This is their business. We don't involve in pacts trying to stop people unless it affects our entire security, which it doesn't. So I think the other thing is the place in, I think about Southeast Asia is ASEAN. ASEAN has now become an important common market, and it will be an important trading bloc. It's called the third wave now, after China. So what is the factors for a successful arbitration place? I think they have talked about it just now, Kevin and Ruth, in an oblique way, but this is really what it means. You must have strong and effective arbitration law. You must have a support and sophisticated judiciary, supportive. You must have supportive government and industry. You must have New York Convention status, and you must have a presence of strong arbitral institutions. In fact, in Asia, all the arbitration institutions are there. LCIA is in India. We have ICC all over Asia. So everybody is there, but except the venue is different. And then I think all the countries, again, are members of the UNCITRAL family of legislation, model law. And then institutions, all the institutions have world-class facilities. The judiciary is very, very strong. And I think the more importantly is that various countries work with various institutions to set up institutions. For example, Malaysian KL Arbitration Center is set up under host country agreement with ALCO, Asian African Legal Consultative Organization, which is headquarters in Delhi. It is quite interesting. We have my headquarters is in Delhi. We are a diplomatic mission set up in Malaysia with all the privileges and immunities that the UN or the UNCITRAL would attract. So, okay, I think that I think is the first thing. So, where is concerned going to KL RCA itself is that the cost advantage. I think the main thing we will talk about is the cost advantage. We have all the same things. So then you look at the currency. How strong is your currency? If you are paying a very, very strong currency, then your hotel cost is going to be high, your transport cost is going to be high. The other thing is that you always look at the hub. Is it easy to get in, easy to get out? And then the more important thing is that the panel of arbitrators, I think is pointed out, we all have the same arbitrators on our panel. I have 900 people on my panel, and it's an open panel we can add on. And then we have facilities, stock facilities, capabilities. Our service orientation is the same. We work very hard to attract and provide the service of when we deal with parties and also when we manage the arbitration. The basic thing is that the growth in Asia is arbitration is about economic growth in Asia. And as I think pointed out, a lot of the Russian parties, other parties are all moving to Asia, setting up businesses and all these things. And we hope that you will actually come there to carry on with that business. Now, we have actually multilingual arrangements. We have translation of various rules. We have fast-track procedures. We have emergency arbitrator. There is actually easy access. Arbitration in Malaysia, if you are coming in for arbitration in Malaysia, you can fly in and fly out. Counsel can fly in and fly out. Arbitrators can fly in and fly out. There's no withholding tax. It's all the same regime. Everybody, we have to have that. It's almost like a standard. So I think that when you're now looking at the effect that you are suffering political issues, then it is actually obvious that you have to move to Asia. I think it's no more choice. In fact, by moving to Asia, you are sending a message that the marketplace is competitive. It is a competitive marketplace. You have to behave. The business goes where people actually provide service. So I want to actually show you all, in conclusion, that we too have a very large building. In fact, we just inaugurated this building last year. It has 20 hearing rooms, world class, with full facilities. Thank you very much. I try to keep it.
Thank you. We now have commercials for at least 3 prominent institutions. Might be time to take a slightly different perspective and give the floor to President Akira Kawamura, who chairs the Japan Association of Arbitrators. You have the floor, sir.
Thank you very much, Chairperson. Thank you. Let me have my let me introduce myself briefly. I was the president of the International Bar Association, and I chair the host committee of very successful large international bar annual conference in Tokyo last year, and I had the honor to escort the Emperor and Empress of Japan, and then I now become a president of Japan Arbitrators Association, and my position is not competitive with 3 major arbitration institutions in Asia. My position is to how to keep up with the development of these Asian arbitration institutions. And so I put a two priorities in my capacity as the president. International Arbitration in Japan campaign. I would like to encourage all of the Japanese companies and people to put their international agreements, a arbitration clause in Japan. And the second priority is building a regional international arbitration center in Japan, which is well tailored for the needs of the Japanese companies. Let me explain why these are the important points. As introduced by Kevin or other people, new arbitration centers are growing dramatically in Japan, in Asia, especially, I would like to point out, after the global financial crisis. The SIAC, SISE will be the most remarkable and successful example among them, according to its 2013 annual report. After the global financial crisis, the number of new cases submitted to the SIAC increased from 99 in 2008 to 259 in 2013. Big increase, almost 2.5 times. Kuala Lumpur Regional Center of Arbitrations is another case. The number of new cases increased from 51 in 2010 to 156 in 2013. Korean Commercial Arbitration Board, Shanghai International Arbitration Center, they are all very new, but increased the cases very much after the global financial crisis. Why? They so grown up in the post-GFC years. First point is the economy transformation in Asia. In the years following the outbreak of global financial crisis, the destination of international trade and investment moved from Western market to new territories in the East Asia and the Eastern emerging markets. The recent sanction apparently may give rise to a similar trend of transformation. As business moves to new emerging territories, the demand for the new internationally viable commercial dispute resolutions became critical in these territories. That is very important reason behind the growth of commercial arbitration in Asia. I must point out, in addition to the transformation of the economy, there are two distinct important reasons which prompted the success of these new Asian arbitration centers, which I think we must learn. First point is they have very strong group of legal profession, arbitration, human resources, very well taught and trained under the common law system, English system. Second point is they were very strongly supported by the government under the context of the trading service, trading legal service. The new, very well-equipped arbitration centers, heavily funded by the government fund, were the notable common factors among those three successful arbitration centers. Arbitration has an uncontestable advantage for international commercial disputes in comparison with the litigations at national courts. It is flexible and independent. and it is an ideal option under newly growing, changing, multicultural and multi-legal system environment like Asia. International arbitration could help and encourage foreign investment and international trade, as pointed out on Wednesday by Mr. Medvedev in his keynote. My main concern is, however, naturally Japan. Japan is one of the largest investors in the region. Japan should be very seriously interested in having an international arbitration facilities. However, it is not the case at all. The number of, let me show you the data. Among the international arbitration markets, the number of arbitration cases in Japan stayed for many years at a very low level, either inside or outside Japan. Even in the forum like SIAC, which has a growing number of international arbitration cases, the Japanese cases are very few. As the president of JAA, I am deeply concerned about this question. A question is why the Japanese companies do not like arbitration so much, either in Japan nor in overseas. Let me explain this. JAA was recently asked by Japanese Ministry of Economic Trade and Industry to conduct a comprehensive survey of investment treaty arbitration cases throughout the world. We did that, and we confirmed that none of Japanese companies or Japanese government had ever sought for legal remedies through the treaty arbitration system, whether as a plaintiff or as a defendant, at any forum, ICSID, ICC, or else. Japanese companies and government agencies apparently do not like arbitration at all. Why? Our survey of several hundred treaty arbitration cases revealed that the large cases are being almost exclusively by a relatively limited number of specialist lawyers and law firms, and arbitrators are chosen by those arbitration lawyers from a small pool of the arbitration community. I would be afraid if the international arbitrations are overly dominated by the traditional Western, I must say, common law legal system and the profession, and I am afraid if it may be the reason why the Japanese companies do not feel comfortable engaging in those international arbitrations and avoid the legal remedies through arbitration. Because if they seek for the remedies through the arbitration, they have to go to London, they have to rely on the counseling of the very well eminent English lawyers like Michael. Joke. I would be afraid it is overly dominated. And I'm afraid by avoiding arbitration, Japanese companies are not legally well protected in the overseas market.
Could wrap up, please.
Yes, thank you. Sorry, soon, I will finish soon. They would be the reason why I, in my capacity as the president of JAA, wants to establish a new regional arbitration center, which may provide our clients, companies, with more culturally friendly choice of the arbitration forum in the region. It is why I think Russia and Japan commercial arbitration center very well tailored for the needs of the Russia and Japan commercial dispute should be a proposition which worthwhile to consider and realistically possible and useful if we may have support from the both governments. Professor Kostin and Vladimir, is this unrealistic idea? I think we may work together with to make realize. Why do the Japanese companies and Russian companies must go to London to seek for the English law and English language solution through the London arbitration? We may have our own way of distribute solution, our own arbitration. Thank you very much.
Thank you. I would like to thank President Kawamura for provocative questions and also for providing an excellent transition to our last speaker to dispel the obvious misconception that arbitration in Asia might be dominated by common law. Who is best placed than a QC? And it's my pleasure to give the floor to Mr. Michael Swinston.
Mr. Chairman, ladies and gentlemen, part of our discussion today is how the Asian tigers of arbitration can invigorate Russian arbitration. Well, I come from the old world of arbitration in London, and also I don't feel very much like a tiger, especially after the legal drinks. So I will leave matters of the Asian contribution and a state agency for their various premises to others. I understand that Russian businesses are looking for new opportunities in arbitration, and I understand also that Russia is looking at a new approach to its system of arbitration. All I would suggest is this, that Russia should not lose sight of the factors which still lead parties to international business contracts to choose English law and some form of English jurisdiction in over 30% of international business contracts. And I would also like to dispel one myth. There seems to be a suggestion promulgated by my colleagues that you can't come to London anymore because of sanctions. Well, I'm sure that those of you who've attended the last few days of the forum have noticed some colleagues of mine from my chambers in London. From their presentation, it's clear, for example, that we act regularly for Iran. We act regularly for Iranian banks. We act for Russia. We act for targets of sanctions, and we do that in order to relieve them of sanctions and to resist sanctions. Now, if we're able to do that actually for the targets of sanctions, I would suggest to you that it's very obvious that there is no inhibition whatsoever on Russian parties coming to do arbitration in London. There's a further point. At the English bar, we have a tradition of fearless and independent advocacy, and we deliver that around the world, including in the very smart new premises that have been mentioned here this morning. We do it in Hong Kong, Singapore, Qatar, Washington, everywhere in the world where serious arbitration is fought. And also, it's important to note that because we appear in so many of these places, we are regularly called upon to deliver a mixture of civil law and common law in submissions. For example, in Qatar, if you tried to argue purely in terms of the common law, you would not be listened to. You must distill principles which are common to civilized legal systems around the world. Now, what can I say from the old world of arbitration? The first point is that a key requirement of a functioning and respected arbitration system is the integrity of arbitrators. How do you build that when you're trying to build a new approach to arbitration? And does state regulation have a role in achieving this? There is no easy answer to that question, and the factors in the debate are, on the one hand, an ability of the state to try to prevent corruption and try to insist on proper qualification of arbitrators, but on the other hand, a perception of risk in terms of state interference with the arbitration process. And I know that this is topical in Russia, but it's by no means just a Russian debate. There is a perception in Europe that corruption is a grave risk to arbitration, and the additional protocol to the Criminal Law Convention on Corruption now requires EU states to introduce an offence of bribing an arbitrator. There's no smoke without fire. I myself saw for the first time last year, in relation to a continental arbitration, proof of inappropriate payments to an arbitrator, the first time in my experience. So what's to be done about this? Well, the EU has adopted a new approach. In the EU-Canada trade agreement, there is provision for arbitrators to be drawn from a roster pre-approved by the states involved of people who are regarded as having probity and appropriate qualification. And the EU is also proposing that in relation to the transatlantic trade and investment partnership. It's fair to note that Romania has gone the other way, and they've legislated for entire party autonomy because there's a lack of faith in the arbitration bodies which otherwise appoint arbitrators. Well, what about the position here? And I make my suggestions with hesitation and deference, because it's hardly a European's place to make suggestions how Russia should conduct its affairs. But I would say this, that Russia's reputation as a seat of justice has improved in recent years. Only in 2008, a leading decision in London suggested, on the evidence in that case, that it may not be possible to get a fair trial in Russia where a state interest was involved. Contrast 2013, when the Supreme Court in England noted that there was no suggestion that a fair trial could not be had in a dispute between VTB, a major Russian bank, and Nutritech. Now, that transition in perception of Russia is due in no small part to this legal forum and the efforts of the Ministry of Justice here at engagement with law and lawyers around the world, which has opened up Russia and actually removed some misconceptions to some degree as to the Russian system. Now, of course, against that background, I would suggest that endorsement or approval of arbitration centres here by the Ministry of Justice, which has that reputation abroad, would be a good thing for Russian arbitration. But I would also add that, as we say in England, the proof of the pudding is in the eating. And the only way of establishing a reputation for efficiency, probity, trustworthiness is a continuous history of incorruptibility. Now, it will take time for this to be built, but if you don't want to wait, you can always come back to the old world. There are no inhibitions on you doing so. Thank you.
Thank you very much. And on these hopeful remarks, I see we still have about 15 minutes for discussion. That is less than we anticipated, but maybe we can start immediately. So are there any questions from the floor to any of our panelists? Yes, please. I think you should have a microphone coming your way. It is on its way. So if you would please identify yourself and ask a brief question. Thank you.
Thank you very much. I'm Yoshi Hayakawa from Japan, and I'm serving as a delegate for the UNCITRAL, some working groups. And I'd like to follow up Mr. Kawamura's very provocative intervention. And I have one question to the present speaker from London. And my comment to the Mr. Kawamura's very, the advocative proposal is very based on the present situation, especially the Japanese business and legal community have just now some kind of concern. And according to the statistics, the 80% of the Japan corporation-related cases are flowing outside of Japan. And these disputes are resolved in the outside of venue of the Japan. Of course, Japan business companies are now a very good customer for the, the foreign arbitration institutions. But in these 10 years, we realized and surprised of the very, the surprising expansion of the Asian arbitration institution, especially for the SIAC or Hong Kong International Arbitration Center or some others, including the Kuala Lumpur one and the Indian ones. And we realized we could deal with our own disputes inside of the Asia. And that is the base of the, his presentation. And his final, the present proposal is a little bit too provocative, but we could, step by step, made something between the Russia and Japan, or Russia and some other Asian countries, and we could deal with this kind of the dispute within the Asian issues. But of course, we have to, make our rules or institute neutral and reliable. And perhaps, the UNCITRAL rules are, very useful for to keep such kind of the neutrality or independency, and I believe. And another question is, I'm very, have a great interest on the previous explanation from London, and especially European people have a strong concern or interest on the neutrality. But I have some doubt about the idea of the list of arbitrators. And because I'm deeply involved in the sport arbitration, and you pointed out the example of the CAS, Court of Arbitration for Sport, and they have a list of arbitrators. But problem is, perhaps the list of arbitrators are 250 or 300, and unfortunately, not all of the list arbitrators are real expert for the sport ones, and sometimes we are a little bit surprised for their own arbitral award, and especially for connecting to the anti-doping issues or some other issues. So sometimes such a list of the arbitrators are created by the very political decision or some other reasons, and we have to pay attention to the how to create such kind of the list of the arbitrators. That is my comment and question. Thank you very much.
Thank you. Would you care to respond?
Well, I should say that with some presumption I presented a European perspective, but what I really meant was a London perspective. And in the same way that I wouldn't compete with a state agency from the Far East, I wouldn't sing the praises of every European arbitration system. But I do sing the praises of London, because arbitrators there drawn from very expert specialist judges, retired judges, and practitioners who've got very great experience in their field. And I would suggest that a mark of the respect for that system and its administration of law comes from the fact that a number of my colleagues, in selling their now rival systems, made the point that they had a very good heritage from English law and perhaps the traditions of English advocacy. What I would suggest is that if you want the fountain of that expertise, you should go to the source.
Thank you. I think there was another question, the gentleman. Please identify yourself and please state a brief question.
I will indeed. John Hines, Morgan Lewis Law Firm, Moscow. I have two brief questions. One, I would just like to know from our colleagues from Singapore and Hong Kong, what is the average dollar value of the yearly claims they have and what has been the trend? And then for Mr. Swainston, I would ask, you have made more eloquently than I would some of the points that I was going to make listening to this session, but I have a question for you, which is sparked by what you said. I have seen recently arbitration clauses offered by some of the Russian state companies who are afraid of the sanctions, providing for, let's say, Singapore arbitration, but still wanting English law. Now, there is the provision in the EU sanctions which calls into question the, let's say, enforceability of a claim where the sanctions might protect the defendant of the claim. Could you make a comment on that? Do you see any obstacle there under English law?
I think there are two aspects to the question. One I attempted to address in my presentation, whether English lawyers, English barristers can act for the benefit of sanctioned entities. And the answer to that is yes, they can. What happens is that you obtain a license from the Treasury to receive fees and so on. There's never any inhibition on that. And indeed, the sanctions regime so far has never interfered with legal representation. And if it ever did, I would be leading the charge for judicial review to nullify the relevant measure, because that would never stand in England, certainly amongst the legal community and the judges. I think the second aspect is whether businesses really have to worry about enforcement of their contracts if they have arbitration in London. For the reasons just mentioned, we still do, and we do a burgeoning amount of Russian, Iranian business in London. In my experience, it's not an obstacle to the conduct of arbitration. There is what I mentioned yesterday, a penumbral effect of sanctions, and especially American sanctions, and there can be reluctance of some arbitrators to take part, and some have withdrawn if they've got an American background. But that's not been the case with English arbitrators. In my experience, awards are rendered. There may be issues of enforcement around the world of those awards, particularly in favor of a sanctioned entity, and that really depends upon the jurisdiction of enforcement. Just picking up your other point, it is the case that Russian parties are looking at other venues, but still at English law, because they like English law. And that goes back to my first point, because wherever the venue is, say Dubai or whatever, you can choose English law and you can still have English advocates presenting it.
Thank you. Would you please Hong Kong?
Just very quickly in relation to the average dollar amount, I think it's very difficult to see a trend. We see it differ a lot from year to year. We see cases from the very incredibly small up to the very large cases in the billions of dollars, and really everything in between. And from year to year, what our average is quite different. So I can't really pinpoint it for you.
Thank you. Singapore?
For Singapore, we're certainly seeing higher value disputes. Our total sum and dispute was $5 billion last year, $6 billion in 2013. But in terms of your most typical dispute, sort of your median dispute, it would be in, say, the 5 to 10 million USD range.
Renaud.
More questions?
Sorry,
please.
Thank you, Chairman. I'm Mohan Peris. I was a senior prosecutor, private practitioner, Attorney General, and the last Chief Justice. My question is to Kevin. The establishment of the commercial court to try international disputes, was the rationale behind that? What is the rationale behind that? Is it simply costs?
I don't want to speak with too much authority for the Singapore International Commercial Court, but I think what it is just providing all manner of dispute resolution. I mean, certainly there are some comparative advantages to international litigation in terms of arbitrability, joinder, situations like that. So I don't think it is just costs.
Just one little question to the panel again. I've been involved in perhaps the biggest arbitration proceedings we have back in Sri Lanka held regarding hedging transactions with 3 international banks. I was just wanting to throw up the idea whether it was time to do something about the unbearable costs that follows the sophistication that we see in your arbitration proceedings and your venues in respect to smaller jurisdictions such as ourselves, because that actually dissuades us from invoking the facilities in these very sophisticated arbitration venues. The sophistication doesn't come cheap. They are expensive, very expensive. Transportation of counsel from one end of the world to the other end. Hotel costs, transportation of documents, shiploads of documents, or plane loads of it. So that's something I would strongly urge, that the centers begin to be sensitive to the fact that smaller jurisdictions cannot afford the luxury of such sophistication.
Can I?
Very serious question. I think
yeah,
not only members of arbitral institutions should reply this.
Thank you, Mr. Chairman. Actually, Kuala Lumpur Regional Center is specifically targeting that.
we realize is that the issue is really cost. And when you come to Asia, it depends which center you go to. If you go to a center that is already expensive, then the cost will be there. And then again, are you importing all your talent to argue the case? If you import a talent from a QC from London, you are going to pay QC rates. So I think there's no running away from that. And then whether you can bring your own people in is also very important. So I think that is the one. The other issue which I'm picking up from the gentleman who asked the first question is the issue of whether you're going to import the arbitrators. Arbitrators, if you bring them from the West, they are going to cost that kind of money. Because in fact, I think the Asian centers will always look for someone in the region. So that is now becoming quite a reality. I think Asian centers will look at people on the panel who can deal with it within the region, who will be neutral and have the expertise. I think we are addressing that. Like many of the centers actually also have fixed rates. An ad valorem rate, I think we follow that very strictly sometimes. And then if parties cannot agree, then we will actually say this is the rate. And if the arbitrators don't accept it, too bad. We got so many other arbitrators who will do it. Thank you.
Just one brief comment on the position of institutions in relation to costs. And I think I can speak for every institution here. We do often have within our rules various mechanisms that can be used by parties. For example, the expedited procedure, which means you have resolution quickly, therefore it costs less. I'm sure we all provide very similar levels in terms of video conferencing. You can file things electronically. You don't necessarily have to be sending the documents. If you use the video conferencing, you're not having to send the people. So I think the majority of costs in arbitration does tend to be from aspects that we don't have that much control over at the institutions, council's fees, travel costs, things like that. And there are ways for those to be reduced. And if you look at the services that the institutions provide, we do provide ways to reduce the aspects of the costs that we actually control.
Perhaps I think the Minister has to leave us, and I would thank him again for being with us this morning. Maybe we have time for one more question.
Thank you. Charles Claypool from Latham & Watkins in London. I've got a question for the representatives of the Singapore and the Hong Kong institutions. You both advertised your institutions as being sanctions-free. Obviously, well, it seems to be the case that you're from countries that have imposed sanctions, and I just wondered whether the nationality of individuals working at your respective institutions, particularly US nationals, and in light of the broad concept of facilitation, whether that is an issue in itself.
This is something that we've considered. We have only one American working in our centre, and we would probably take steps to have them not involved with the case if it was involving a sanctioned entity. It's not something that we've had to deal with yet, but we would approach it with an abundance of caution and try to have no question arising from that issue.
For Singapore, we have U.S. qualified lawyers, but no U.S. nationals, so we haven't had to deal with this question as of yet.
Well, I think with this we have come to the end of the time allotted to us. That we confirm that. So I would thank all the panel members and the audience for being here still in fairly large numbers considering the time and the length of the evening yesterday. So thank you very much.